this morning. I want to welcome you all to your positions. This is a really exciting day. For the next hour or so, we are going to be talking about the Bagley-Keene Open Meeting Act, which turns out to be a critically important law that governs the meetings of state bodies. It's designed to ensure that they conduct their business openly and that they really engage the public in their decision-making process. Another thing that we'll also be talking about this morning are some of the very specific requirements contained in Prop 11, the Voters First Act, that apply to your meetings and to your communications. I know that all of you have been through this very extensive application process, and you know that when the voters approved Prop 11, it was their design to fashion a redistricting process that is incredibly transparent. So one of the things that they did was to put in place certain requirements in the law, in the Voters First Act, that go above and beyond what Bagley-Keene requires. And I will be drawing your attention to those differences today and talking about some of those specific things. I know that before this meeting, you received the Bagley-Keene Handbook, which is prepared by the Attorney General's Office. I think you received that electronically, and you also received a legal guidance memo. I strongly promote the use of the Attorney General's Handbook. It's a wonderful resource because it ties together the law with practical examples all in one place, and it's very readable and useful. At least in my experience, it's been great. If you have questions at any point, please interrupt me. I know you don't have mics, but if you have a question, just stop me, raise your hands, or do whatever gets my attention. Why do we even have an open meeting law? I think in some respects the purpose of this law is almost self-evident. It's to make government decision makers accountable to the people they serve and to give the public a voice in the decision-making process. There's a wonderful phrase that a number of courts have used when they've been addressing challenges to compliance with the Open Meeting Act. They refer to the rights that the public has as having the right to a seat at the table. And I love that phrase because it really conveys this idea that they are there with you, engaged in and participating in the decision-making process. They are not passive observers of what you do. They have the right to be heard by you and to really be engaged in the process. And there are some very specific ways that we'll talk about today that the law ensures that those rights are protected. If you're like me, and I'm a little bit of a law geek, I always like to know where laws come from. And like many other open government laws, it came about as a result of some reform efforts. Back in 1950s, some journalists who worked for the San Francisco Chronicle were trying to follow what they considered to be some very important governmental decisions that were being made in the city of San Francisco. And they spent weeks traveling around the city trying to figure out where meetings were being held and when. All they could see was the end result of important decisions being made, but they didn't know when they were happening. They wrote an expose that they published in the San Francisco Chronicle, which they entitled Your Secret Government, which relayed to the public the fact that important decisions were being made in secret. That, in turn, led to the enactment of the Brown Act in 1953. Many of you may be familiar with this law. This is the law that governs city council meetings, county board of supervisor meetings, school boards, other local agencies. That law was put in place in 1953, and then 14 years later, in 1967, the legislature basically embraced the same elements of the law and put them in place for state bodies, bodies that operate at the state level. For those of you who may have served on local boards and commissions, the Brown Act and Bagley-Keene are very, very similar, just a few minor differences, and if it's helpful, I can address what those are as we move through this training today if you have questions about that. The Bagley-Keene Open Meeting Act really all centers around one very basic central premise. That is that meetings of state bodies have to be open to the public. To understand what that requirement means, though, we really need to look closely at how the legislature has defined what a meeting is and who a state body is, because those two terms tell us a lot about when the requirements of this law are triggered. So, what's a meet? Oh, let me talk first about who's subject to the law. Who is subject to it? What's a state body? What does that mean? It's virtually every multi-member state board or commission that's charged with decision-making. The list is incredibly long. Almost every multi-member state body you can think of, the State Board of Equalization, CalPERS, State Water Resources Control Board, State Board of Education, and the list goes on and on. Multi-member state decision-making bodies are charged with complying with the Open Meeting Act. Another really important way in which a body can become subject to this law is when there is an advisory board or commission of 3 or more members that is created by another state body. This may turn out to be very important for you as commissioners as you do your work on the Citizens Redistricting Commission. You're a 14-member commission. You have a very short time to perform an incredibly extensive amount of work, and you have to travel and reach out to the public to do that. One of the things that you may decide to do as a body, as a 14-member body, is to form smaller subcommittees that go out perhaps and do fact-finding or that reach out in different communities. If you form an advisory subcommittee that is made up of 3 or more persons, that becomes yet another state body that has to comply with all of the requirements I'm describing here today, the prior notice, meeting openly, etc. So something really important to keep in mind. Not a bad thing, but just an important thing to be aware of as you do your business. There's also a requirement under Bagley-Keene that even when 2 members of a state body are given what's called delegated authority, which means that they are actually empowered to go out and make decisions on behalf of the full state body, that they actually have to meet openly in compliance with Bagley-Keene. That won't be relevant for the Citizens Redistricting Commission because it has no legal authority to delegate its decision-making power with respect to redistricting. It must make all of those decisions as a full state body. And so as you think about conducting your business, and I know that you'll be talking about this more today, the formation of various subcommittees by law has to be for the limited purpose of sort of going forth and listening to the public, doing fact-finding, hearing from people, and then bringing back what you hear to the full commission. There's no authority for this commission to delegate down to subcommittees any real decision-making authority, which is a separate issue from Bagley-Keene, but a very relevant legal concept. So Bagley-Keene clearly applies to the Citizens Redistricting Commission. The Voters First Act makes an unequivocal statement about that fact. It applies to the full 14-member commission. It also applied to the first 8. They, in a sense, acted as a state body for the limited purpose of selecting the final 6 commissioners. And again, as I mentioned, it will also apply if the full commission forms subcommittees of 3 or more to do any business on its behalf. A really important point to keep in mind as you do your work is that the requirements of Bagley-Keene are a floor, not a ceiling, in terms of the degree of transparency and openness that you may choose to embrace as you do your business. It sets out minimum requirements for notice, for public comment, for those kinds of things. As you move forward in your business, there may be circumstances where you decide that there's more that you should do to reach out to the public. There's some things you have to do because the Voters First Act tells you you have to do them. We'll talk about them now. But even if you're not required by law to do those things, there may be times when you want to reach out and do even more in terms of public access. To understand when the requirements of the law are actually triggered, we have to know what a meeting is, because we know your meetings have to be conducted openly. So what does that mean? The traditional definition of a meeting is that it means a majority of the members meet at the same time and place to hear, discuss, or deliberate on any matter that's within the subject matter jurisdiction of the body. That's kind of the traditional notion. You have a quorum, a majority, a simple majority present. But I want to really draw your attention to the verbs that are used in that definition, because a meeting has a really broad meaning. It includes circumstances, not just where you act or vote on a matter or commit yourself to some formal course of action. It's much, much broader than that. It also encompasses circumstances where you are hearing, discussing, deliberating. So, for example, you may find as you do your business that you have a need simply to take testimony and listen to people, and we know that you will have to do that, and you may be far from the point where you're ready to make any decisions. But that hearing from the public and the questioning of the public, that is all something that has to be done at an open public meeting. The public has a right not only to see you make decisions, but to see your full deliberative process, the process by which you acquire an understanding, learn, get information, resolve differences among yourselves, reach consensus. All of that has to be done in an open public setting. When the open meeting laws were in their infancy, there were some public officials who thought, well, we know we have to vote in public, but let's have a pre-meeting, kind of hash things through, reach consensus, and then we'll come back into the public meeting and vote. The legislature and the courts quickly let everyone know that that was not what they had in mind under the Open Meeting Act. It's the full deliberative process the public has a right to observe and participate in. Some of the other requirements, which you're probably all very familiar with at this point, but I'm just going to kind of give you a quick tour of them. Everyone has a right to attend a public meeting. There's no question about that. Public meetings have to be held in a place where they're accessible to the public. They have to be accessible to individuals who may need special accommodations under the Americans with Disabilities Act. Your agenda describes how to request special accommodations if you need them. The media absolutely has the right to attend and to record your meetings, subject only to reasonable restrictions in the sense that they can't interfere with the ability of the public to observe or participate in the meeting. Just common sense kind of application. People have a right to record your meetings. There's no ability for a public body to say, no, you can't stand there recording me with your smartphone or your tape recorder. The public has a right to record the meetings. In addition, people cannot be required to sign in to speak and to attend a meeting. Now, what many of you have been to public meetings have probably seen, and you probably saw one here, is a sign-in sheet. But signing in is voluntary, and there's a statement that you need to include on your sign-in sheets that indicates that it is voluntary. So, I want to talk a little bit about notice. It turns out to be a critically important aspect of the law and one that is a constant source of litigation. And this is an area where Bagley-Keene differs from the Voters First Act. The Voters First Act imposes a greater obligation on you in terms of the amount of notice you provide prior to your meetings. Under Bagley-Keene, notice is sufficient when it's published on the internet 10 days prior to a meeting. Clearly, the voters wanted more public access, greater notice when they drafted the Voters First Act. So here's how things work, and I'm going to draw your attention also to a little bit of a twist in the law. Under the Voters First Act, the full commission is generally required to provide 14 days notice prior to its meetings. That's the general rule. That's the rule that applied to this meeting, and that is generally applicable. Now here's where it gets kind of interesting. With the approval of Prop 11 in 2008, the voters recognized that at that point, the completion date for the maps was September 15. The voters recognized that you would likely need to meet on fairly short notice in the month of September. You're going to be very busy fine-tuning the maps, finalizing your work, so they created a limited exception that allowed you to call meetings on 3 days' notice. Then what happened at this most recent statewide general election is that the voters approved Proposition 20, which expanded your responsibilities, but it also changed the completion date for approving the maps from September 15 up to August 15. Unfortunately, Prop 20 didn't pick up and make what should have been a corresponding change that should have allowed you to call your meetings on 3 days' notice in August of this year. Okay, call it a drafting issue or a glitch, whatever you will. I drew the First 8 members' attention to this as well when we met about a month ago, and I'm pointing it out to you as well. There is a fix. There's a couple possible ways that you can fix it, and I can throw out what I see as probably the easiest, most straightforward way to fix the problem, but you'll probably want to consult with your counsel further on this issue. The Voters First Act actually has specific provisions that allow the commission to actually propose in specific language change that they believe is needed to the act, and it requires a 2/3 vote. So you can certainly consult with counsel on that. A 2/3 vote bill would take effect immediately as an urgency measure, but you would need to find a member of the legislature who's willing to carry that bill as an author. So that's one avenue for addressing this problem if the commission believes that it needs to fix that problem so it can meet on less notice in August of this year. So. I'm going to just highlight now, I touched earlier on the fact that the Voters First Act clearly imposes obligations on you that go beyond Bagley-Keene, and here are just some of the ways that it does that. First of all, it actually requires the commission to conduct an outreach program to solicit broad public participation. This may not seem like a big deal, but it is. I mean, the voters clearly said it's not enough to do what most state bodies have to do, which is simply publish their notice on the internet. You have a real duty to reach out. You must go out and actually have an outreach program where you solicit broad public participation. And I know, as all of you have gone through your interviews, you've heard a great deal about this. The Bureau of State Audits did extensive outreach when we were doing the application process, and the law contemplates a continuation of that kind of outreach to engage the public. Another way in which the Voters First Act is different from just what the standard requirements of Bagley-Keene is that you actually must conduct hearings before you draw any maps. You must hear from the public before you even start to construct the maps. It makes it very clear. It's not permissible for you to deliberate and draw maps and then say to the public, what do you think? You must hear from them first. You also have a specific duty to publicly display your maps for 14 days, and that goes hand in hand with the 14-day notice requirement for your meetings. And I really have to highlight this requirement. To me personally, it's one of the most effective ways that the drafters of Prop 11 have really ensured meaningful public participation in the process. The normal rule that applies under Bagley-Keene when you hold a public meeting is that if the members of the state body have received written documents or materials to assist them with their decision making, those materials don't have to be posted on the internet. They only have to be made available at the meeting. So the typical interested citizen walks into the meeting and sometimes sees a considerable amount of data and information that they're just seeing for the first time at the meeting. This is really different. Now interested members of the public are going to have a full 14 days before the meeting where the maps are going to be on public display. They'll really have a chance to review them and contemplate and think about what kinds of public comments they want to offer up. Sure. Yes, you really do. You have to have the basic substance of the final maps ready. That's an issue that I would encourage you to talk with your counsel about in terms of what change would be permissible under the law, because it does talk about maps being on display for 14 days. Now, whether minor changes can be made, those kinds of things, you'll want to get some guidance on that. Yeah. And you have to take public comments, all tied together. You have to take public comments on the maps for at least 14 days. So these are very important requirements. You may want to use the mic for recording purposes. That's actually a great point, since I know you're recording. Yes.
I want to make sure that I understood your last point clearly. You said that in some total, they had the maps that were available for public comment for 14 days. Does that mean after every change for 14 days, or?
Well, before you take any action. So, and again, these are really good questions, and some of this is going to, these are going to be the kinds of things you'll get some really good guidance from your counsel on. And depending on how often you fine-tune the maps or how many iterations of maps you have, you could trigger a lot of 14-day review periods. And so. Although there are these, respective 10 and 14-day notice requirements under Bagley-Keene and under the Voters First Act, there is I'll just draw your attention quickly to provisions in the law that create some exceptions to that do allow state bodies to meet when they provide less notice, less of a notice period. One is called a special meeting, and as its name suggests, a special meeting is different from a regular meeting. It can only be called for very limited purposes. Usually it's called because you need to take disciplinary action fairly quickly against an employee, or there's pending litigation and you have a real urgency around taking appropriate action. When you hold a special meeting, you only need 48 hours notice. But one of the things that actually makes it sort of financially burdensome is you have to actually post the notice in newspapers of major circulation. It's not sufficient just to post it on the internet, so there's an added cost. But there are certainly circumstances where it's just simply necessary to call a special meeting. In addition, there's an ability in the law to call an emergency meeting on just 1 hour notice when there's some sort of real natural disaster or crippling disaster that requires immediate action. Based on the jurisdiction of this commission, it's unlikely that you would find yourselves availing yourselves of that exception. In addition to the time that before your meetings that you have to provide notice, there are also really important requirements related to the substance of your agenda. This is another area that is, very ripe for litigation, and it's really important to be sure that when you publish your agendas prior to your meeting that they meet the legal requirements. What the law tells us isn't particularly helpful. It says you need a brief description of each item of business to be conducted, and the courts have told us that has to be specific. So what does that mean? How helpful is that? What we know from the case law is that when you publish your agenda, when you describe the items of business that you're going to conduct, it should put a reasonable person on notice of what you're going to do that day. It should be descriptive enough that anyone who would have an interest in that would really know, well, what are they going to do today? So for example, if you get to that point in your business where you're going to approve maps, you don't want to have an agenda item that says the commission will generally discuss redistricting. That's not very descriptive. That hasn't really provided the public with sufficient notice that this is indeed the meeting where you're going to actually approve maps. You want to be more specific enough to give reasonable notice. So now that I've told you should be specific, the cautionary note that goes with that is that you don't want your agendas to be so descriptive and so precise that they end up tying your hands. So let me give you an example of what I mean by that. There's an important appellate case where an agency published its agenda, and on its agenda it described what particular problem it was going to be solving, and it said that it would be taking up a certain solution to that problem at the meeting that night, or not that night, but at the meeting. When the officials got into the meeting and started hearing from the public and deliberating among themselves, they realized that solution wasn't going to work, but there was another one that was better. So that was the solution they decided on and adopted. Well, they were challenged, and they lost. And the court said, you didn't provide the public with notice. There was no prior notice to the public that the adoption of this solution was even a possibility. So be a little careful as you formulate agendas so they don't seem so precise that the public might think you're only going to adopt one particular solution, or don't narrow yourselves too much in your agendas. And you'll have counsel, you'll have staff who will have experience with this and will guide you on this. So, did you have a question? No. There's a specific requirement in the law related to taking public comment. And I know I mentioned this earlier, a key part of Bagley-Keene is this notion that the public really gets to participate. There's a legal requirement to take public comment before you take any action. Now, many of you may have sat on local or state bodies before, and there's a reasonably standard sort of structure to every item of business that public officials usually do, where the chair will introduce the item, bring it forward, set the stage for the discussion. The members will deliberate among themselves. Someone may make a motion. The appropriate time to call for public comment is before not after voting, of course, calling for public comment, typically while a motion is pending, but before the vote has been cast on that matter. That's required. You have the prerogative as a state body, you can set reasonable time restrictions on your speakers. Should be done in a fair, even way. As a body, you may make a decision that you're always going to allow a certain amount of time, you know, for speakers. You may tailor it more precisely to the kind of meeting you're having or to the number of speakers you see. You know, you have that ability, but you want to be fair. One of the things you don't want to do is be in the middle of hearing testimony on an item and decide midstream you're going to change the amount of time allotted. You've allowed the first 10 speakers 5 minutes, and now we're going to change it because we see that the line is growing. You want to come up with fair, even-handed practices for time limitations. I mentioned earlier, speakers can't be required to sign in order to speak. I know it's a matter of convenience, and we have a lot of legitimate needs as a state body to know who's presenting to you or providing testimony, but you can't compel them to offer up their name in order to offer testimony. Did you have a question? They don't, and that's the interesting twist. I know they don't. Many local agencies this has been an issue recently. You can't actually require people to identify themselves in order to speak. I completely understand that it's desirable from the perspective of the public officials. You want to know who's talking to, you want to know who they're representing and what organization it is. In all my years of interacting with various state and local bodies, I don't think I've ever seen anyone refuse to identify him or herself, but they can't be compelled to do so if they refuse, and they have to be allowed to speak. So First Amendment issues. So interestingly, the public has an explicit right set out in the law to criticize the state body, which I find really interesting. So, yes, did you have a
question? When a person from the public speaks, should they address the full body of the commission, or can they address one commissioner specifically? Is that advisable?
Well,
we
that
allow
isn't
that?
so much an issue around the Open Meeting Act. If you're all present at the podium and they direct your comments to one person, that's permissible. Under sort of a strict purist view of how the rules of procedure work, they should be addressing the chair or the full body. They shouldn't really be singling out a particular member during public comment. So.
Thank you.
There's also a very a customary practice. It's not one that's legally required, but a customary practice that many state and local bodies follow, where they allow room on their agendas to take public comment on issues not on the agenda. And the purpose of this is to hear from the public about matters that they're not dealing with that day, but for the purpose of future planning and knowing what the public might be thinking about that they're not taking up. So the important issue to keep in mind here is if you decide to do that as a matter of practice, and it is fairly customary, is that when people bring those issues to your attention, you can't deliberate on them at that meeting or discuss them or act on them in that meeting because you haven't agendized that item. You can just have a limited discussion for the purpose of deciding whether you want to place that item on a future agenda. And I think are you going to do that today? Si, are you going to have public comment not on the agenda? Are you going to have public comment not on the agenda today? Didn't mean to catch you off guard. I think I.
No, it's fine. I mean, it was something that I wanted to bring to the chair's attention and see how he wanted to handle it.
Yeah.
Because we've got these meetings scheduled
Yeah.
on a continual basis.
Yeah.
But as you say, it's usually customary, but also it's customary to do meetings in one day. And this is never happened.
It's all new, yes. So, I mentioned this earlier, and I'm going to highlight it again. Another requirement under Bagley-Keene has to do with making written materials available. So I mentioned earlier that the standard rule that applies for most state bodies that are just subject to Bagley-Keene is that when the members have written materials that have been provided to them prior to the meeting, they only have to be made available at the meeting. You have a special obligation that applies strictly to your maps, but not to your other documents, to make them available 14 days prior to acting. You may choose, and this is an area where you may or may not choose to hold yourself to a higher standard in terms of making other written materials available prior to your meetings. The client that I advised previously had a special statute that applied to it. They had to make all of the written materials that were provided to the members of the State Board of Education prior to a meeting available on the internet 10 days prior to the meeting. And the idea, of course, being they're making very, very complicated decisions. It's not really, it's putting the public at a disadvantage to walk into a meeting to find a binder this thick of data and information. So, but the trade-off, I will tell you from prior experiences, it's sometimes difficult to have all of that material ready to be posted on the internet prior to your meetings. So. There is a limited ability in the law to hold what is called a closed session. This is the ability for you to actually convene out of the public eye and not in an open setting. It's limited to specific situations. You can only meet in closed session for those circumstances that are expressly allowed in the law, and there's a long list that I won't go through now. It's not, most of the exceptions aren't going to apply to you. The two that are most likely to apply to you are to deal with personnel matters. In fact, you have a closed session today for that very purpose, and also for pending litigation. There are a few others that might apply to you as well. When you hold a closed session, there's a specific way of conducting it. Your agenda has to state the fact that you will be going into closed session and indicate the legal authority for doing that. At that point in the meeting, when you go into closed session, you'll indicate we're now going into closed session. Members of the public will be asked to leave the room. The mics will be turned off. The room is secure. Minutes must be taken of closed session, and a staff member has to be present. And if you actually take any formal action or vote, commit yourself to a course of action in closed session, when you come back on the record, back in open session, you need to report out on that. And typically counsel will report out on action that you have taken. So you may be having a confidential deliberation about hiring someone. The public does not have a right to observe that deliberation or to know what you may have said about the person, but if you commit to hiring someone, that decision must be reported out in open session. So. There is an ability, and you know this from your experience today, for members of the commission to participate by telephone. And I have to tell you that this is an area of the law where the law hasn't really kept pace with the way we all live our lives and use telephones and cell phones. It's sort of set in a time when people had phones with cords and we're in one place. And so it has some very specific requirements that apply to people, members of the commission who want to participate by phone. You have to be at a location that is actually ADA accessible. You have to be able to put your phone on speakerphone so that interested members of the public who may want to be there, can hear the meeting. A member has to be at that location. Probably the most significant thing is that the address has to be noticed on the agenda. And this is the thing that is always really difficult for many public officials, is that somehow you have to know, in your case, 14 days in advance, that you can't make it to Sacramento for that meeting, and you're going to be at exactly what location, at what time, because that location has to be published on the agenda. And this is the hard one. This catches public officials all the time, especially busy people who travel. They do their best, but sometimes they end up not being able to participate in a meeting because of this requirement. And obviously you can't talk on your cell phone while you're driving. You can't do that anyways for other reasons. So I want to talk now about what really is the primary pitfall in this law, the way in which people end up accidentally violating the law. I told you earlier what a meeting is. It's when a majority of you meet in the same place, same time, to hear, discuss, deliberate, or act. But what the law also contains is a very clear prohibition against discussing the business that's within your jurisdiction outside of a meeting, even if those discussions take place not because you're all in one place at one time, but because you have a series of communications among yourselves that amounts really to a meeting because you've communicated among a majority of the members. Okay, and I want to talk a little bit about that prohibition because this it's a very significant issue, and it's something that catches many public officials off guard. The courts have described several different scenarios, several different ways that people can have these sort of violate the law and have an illegal meeting. They refer to they use the term serial meeting because usually an illegal meeting involves a series of communications outside of a public meeting. It can happen through email. It can happen through phone calls, text messages. It doesn't matter what the form of the communication is. It's irrelevant. If there is a series of communications that occurs among a majority of the members outside of a meeting, even if you don't reach an agreement on the matter, but you're just discussing it, that is a violation of the Open Meeting Act. The courts have these interesting ways that they have described the variations on how you can have an illegal meeting, and they've used the term wheel and spoke to describe another kind of illegal serial meeting. And here, there's a person at the center of the wheel, a facilitator, who's probably not a member of the state body or the commission, but that person ends up facilitating an illegal serial meeting because they, in turn, have a series of conversations with the members of the state body, or sort of at the outer edges of the spokes. Now, I hate to confess this, but the leading case in this area is one where an attorney for a public agency facilitated an illegal serial meeting because that attorney called up each of the members of a redevelopment agency on the phone prior to the meeting and talked with them about a really important decision they were about to make, learned how they would be deciding, and in turn conveyed the information from member A to member B to member C, et cetera, and so on, so that after this series of phone calls made by the council, by the time the members of the redevelopment commission got into the meeting, it was pretty much done deal. They all knew how everyone else would be voting. And that was, of course, a violation of the law. It was an illegal serial meeting. But I want to make a point here about this because even though I'm describing this staff person and this attorney as having created an illegal serial meeting, I don't want you to come away with the impression that you cannot have communications with your staff outside of meetings. That is not true. You absolutely can and should communicate with your staff outside of meetings. It will just be very important that the staff you hire and the council that you hire understand how these rules work, and they really take on the responsibility of ensuring that they do not facilitate an illegal serial meeting. I mean, in my role as counsel, I would talk with individual members of a board. I would know what their concerns were or issues, but my job was to be sure that I never carried forward the thoughts of one member of a board or commission to another member. That is critically important, and staff will, understand those protocols and work that way. And just to summarize what this violation is, I mean, you have a violation of the law when a majority communicate among themselves, whether it's directly or indirectly through the use of a facilitator or otherwise. It's happening outside of a meeting, and it's a violation even if they don't reach consensus on the matter. There's a lack of clarity in the law about that until just a couple of years ago, and the legislature has made it very clear that the communications among a majority, even if they fall short of that majority of the members reaching a consensus or a meeting of the minds on the issue, is still a violation of the law. So I want to talk just a little bit about tips for avoiding a violation of the law. And I mentioned earlier, I'll turn to the second point first, but staff who assist you should be trained appropriately so that they never act as conduits for an illegal serial meeting. And the first point, I will just tell you, this is advice that is very protective of the public's interest. My advice is that members of a state body should not communicate among themselves outside of a public meeting about matters within their jurisdiction. That is my advice to you. And I give you that, and you can certainly seek other advice and counsel from the attorney that you hire to assist you as a full commission. But I give that advice because it's kind of a slippery slope. You may think that if you're talking to one fellow commissioner, you may feel confident that he's not going to talk with anyone else and hasn't talked with anyone else, but there's too much uncertainty around that, and you can't predict whether someone else has actually communicated. And so it's just a slippery slope, and it really destroys public confidence in state bodies when there isn't a perception that the members are really doing their business in public. Sure. Do you want a mic?
The board that I participated in, it was. Testing?
Sure.
Yes, in the board that I participated in, we thought, well, that means we can't talk to each other at all. And we decided that if I was going to talk with Michelle, I would say, Michelle, have you talked to anybody else about this? And if the answer was no, then we could have a little discussion about it. But you're actually advising against that?
I am. And I know that's the other school of advice. And I've been to trainings where attorneys will say to the members, before you have a conversation, ask the person, who have you talked to, who else are you going to talk to? And that's not the advice I'm giving. You're right. So, but I do want to be careful to make sure I don't want you to come away with the impression that you can never communicate among yourselves outside of a meeting. You can, and I'll talk about that in a minute. But the other thing that most state bodies do, and commissions, and this commission may well do, is designate certain people to go forth. You may form subcommittees of 3 to go out, and certainly, they'll have certain obligations. You might also designate certain people formally as liaisons to go work in certain capacity, with the understanding that those 2 and only those 2 will be communicating among themselves about that issue. That's permissible under the law. And then there's certainty. Then everyone really knows what the expectation is about who isn't talking among themselves outside of a meeting. The penalties for violating the law are very serious. There can be criminal prosecutions for violations. If actions are taken in a manner that's inconsistent with Bagley-Keene, they can be found to be void. Attorneys who bring these cases get to recover their fees from the public agency. And perhaps most significantly, it really causes harm to the agency's reputation when it's not viewed as really embracing this law and taking its requirements seriously. I want to talk just a little bit about communications that you can have, because I understand and appreciate that people sometimes feel that it limits their ability to communicate. You can, of course, have purely social conversations with one another, and I would hope that you would, and that you would get to know one another on a social level. You can attend larger meetings or conferences where other people are in attendance, as long as you don't talk among yourselves about your business. That's perfectly permissible under the law. Now, here's another area that I want to talk about where the Voters First Act gets really very interesting and places very special rules on you as commissioners. And these have to do with the way that you communicate with the public and other public officials. The Voters First Act actually puts a restriction on you against communications regarding redistricting outside of open meetings. This is a really unique requirement. Now, for those of you who've participated on other boards and commissions, you all know that if you're on a school board or a city council or a state commission, wherever you go, interested members of the public talk to you and want to talk with you about things you do in that capacity and share their concerns with you. That kind of communication isn't allowed under the Voters First Act. The Voters First Act almost contemplates what I think of as almost more like a formal court hearing or a grand jury type rule, where the members of the commission cannot have those outside the meeting conversations. It is very unique and different. The law requires you, the Voters First Act requires that you adopt protocols around this rule, and that I would assume would be one of the first things that you'll want to take up with your council is, how do we comply with this? What's the right way to go about doing it? Because believe me, I do understand the practical implications of this rule. And it's, you may have people who email you. You can't prevent that someone is going to email you something and talk to you or try to communicate with you about a matter. So how do you address that? And in our guidance to you previously, we said, well, if someone does seek you out, then what these rules would really contemplate is that you disclose that fact on the record in your public meeting. You would say, so-and-so has contacted me, so-and-so has contacted me about this. It hasn't been a two-way conversation. I'm just bringing that forward for the commission's attention. But again, you'll want to adopt really specific rules around this because it's a unique requirement. It's very unique.
So I know that the media is interested in, what's happening with the commission, and some of us will probably be asked directly, what are you doing on the commission? So are you saying we can't say anything, or are you saying that perhaps we can share information that is public right now on the public record that includes the duties of ourselves as commissioners, our strong effort to conduct community outreach, those kinds of things
Absolutely.
are okay.
That's absolutely okay, and yes, and I really, I appreciate the sort of dilemma that I know this is creating for the commissioners, and I know that the press is very desirous of communicating with you, and I appreciate that. What I think this rule is designed to contemplate is that if there are matters that you really haven't taken up yet that really have to be discussed in public, you shouldn't be having sidebar conversations with interested persons outside of a meeting. I don't think this rule was intended to operate in a way that kept the press from being informed about your work. I just don't think that was the intent. I don't.
I understand the intent of this rule, and I'm okay with not speaking with elected or public officials. I'm still not so clear on this first point here, no communications regarding redistricting outside of open meetings, because I've been invited to speak on various radio programs and about the process in general. So I'm still okay in talking generically about the process of redistricting and what this means to the state of California. Am I allowed to do that? Am I allowed to actually go on the radio at all?
You may be, and I really want to encourage you to talk to the council that you hire about the parameters of this restriction, because
Okay.
I completely appreciate the concerns you have, and it's going to take some real thoughtful analysis to come up with practical, workable rules for all of you in terms of what this means. What I really think this rule is designed to get at is that when you conduct your business, when you're really conducting the business of redistricting, that deliberation, that decision-making can only happen in an open public setting. I don't think the drafters meant to hamstring you and prevent you from talking to anyone outside of a meeting. I don't think that was their intent, but you're going to need to interpret this language as a commission.
Donna, let me ask you, does the Voters Act define what redistricting means?
No, and that's where you have some discretion about how are we going to interpret this prohibition? How are we as a commission going to apply and interpret this restriction? What does it mean to have a communication regarding redistricting? And you've really hit the nail on the head. And that is really, I'm not trying to be hesitant in answering your question, but it's really the prerogative of the commission to analyze and interpret what that means and how that restriction applies.
So you're recommending that one of the first things we ought to do is set some rules as to how we handle ex parte information.
That's exactly what the law requires you to do. The law actually has an express requirement in it that you adopt protocols related to communication, and I suspect it ties directly to this prohibition. They want you to sit down and, as a body, and figure out what it means and how you're going to operate consistent with the law under this rule.
I see. Thank you.
And you may want to watch, when we were at our last Bagley Keene, some of the drafters came forward and spoke, at least briefly, about what they had in mind when they adopted these rules. And I hope that I'm being fair to what they said when I'm describing it to you here, because what I really heard them saying is that they want the commission as a body, when it's discussing its work and the things it's going to act on, to be doing that in public. They don't want any one member of the commission out there just hearing something from a group of citizens or a person that the other commissioners aren't privy to. That was really what they were contemplating.
I have a general question too in terms of how to interpret this. If as commissioners in our daily life, if people within the community, our neighbor comes up and would like to express their opinion about redistricting or what they feel about it, and I'm sure with the intent of trying to engage us, or even individuals who maybe have an opinion based on their political connections, they may not be directly connected. What is our position? At this point, I've just been saying it's nothing to be able to be discussed right now, but I'm assuming that's the case. It's not even something. Of course, once they express their opinion, you can't close your ears. But at what point do we engage, or we just politely excuse ourselves from the conversation? I'm assuming that that's what's necessary.
And it probably is what's necessary, but again, the specifics of how you respond to that is something the commission as a whole body should decide. What's pretty typical under sort of, as Mr. Antai said, there are these ex parte rules that apply to certain state bodies. What you would typically do is say, I appreciate what you have to say. I can't really have a two-way conversation with you about that. I encourage you to offer those comments up to the full commission. Please do that. And then when you're in your commission meeting, you would disclose to the commission, so-and-so describe this to me. Now, some communications aren't even going to rise to the level that they need to be relayed to the commission, but others are, and that's where you can decide as a commission, how are we going to handle this? What kinds of communications do we have to disclose to one another? What's even on the threshold, et cetera. Yeah. Another thing I just want to talk briefly about is using technology to promote access. It's so clear from the Voters First Act that what the proponents intended was a really open, engaged process for redistricting. And during many of the interviews that we heard from the applicants, people spoke at great length about their desire to engage the public and to use technology in really innovative ways. So I don't want to sound like a naysayer, but what I want to say to you are two things. First, I absolutely hope that you will use technology in really progressive, innovative ways to engage the public. But when you do that, be mindful of Bagley-Keene and the fact that there are times where it doesn't quite line itself up really neatly with the innovative use of technology, for better, for worse. And I'll just, to give you an example, webcasting is a great thing. We even did some public webcasts when we were doing outreach. You can do webcasting and reach out to a very broad audience and hear public comment and do that all in a way that's entirely consistent with Bagley-Keene. In contrast, blogging can be a little more problematic, depending on how you interpret the word blogging. But if one or more members of the commission were to be engaged in a kind of online blog where they were communicating among themselves outside of a meeting, even though it's public, it's not a properly noticed meeting under Bagley-Keene. Blogging can be problematic under Bagley-Keene. So you just have to be mindful, work with your legal counsel about what is and is not okay in terms of using technology. Couple handy resources that we mentioned earlier. The AG's Guide to Bagley-Keene is a tremendous resource. The Citizens Media Law Guidance is also very helpful, giving pointers on Bagley-Keene compliance. I have just a couple, apparently my questions are way too easy, but I do have a couple questions for you just to see how comfortable you're feeling with this. The first question is, Commissioner A wants to attend the upcoming meeting of a state body. However, she needs to be traveling when the meeting is held. If she calls into the meeting on her cell phone while driving to the airport, is her attendance consistent with the requirements of Bagley-Keene? No, of course not. We know you can't do that, but you're all saying no, but I've had clients call and say, really, I'm in LAX, really? The people, the public can hear me, isn't it okay? And unfortunately, no, because you haven't posted that location on the agenda. So, may a member of the public use his or her iPhone or other recording device to record a state body meeting and then post it on YouTube? Yes. Yes, but only if he or she intends to litigate the matter, or yes, but only if advance notice is given to the secretary, or no? Yes, it's an unequivocal yes, and we all see postings of meetings on YouTube all the time. So, the third question, I offer my comments during the time allotted for public comment on items not on the agenda at every meeting, and the members don't respond except to say thank you. Why? They're not listening. They disagree with you and don't want to argue in a public setting, or the issues you're commenting on have not been properly placed on the agenda for discussion, so it would be inappropriate for them to deliberate. It's the last one, of course. And you will have members of the public who will be sort of disconcerted because you aren't responding. And sometimes the chair will say, just to remind the public, we're hearing from you on members not on or items not on the agenda. We can't really deliberate on those at this meeting. So I know we've gone through this really quickly. I know it's not the most scintillating subject in the world, but it will turn out to be a tremendously important aspect of your work. I know that from having gone through the application process and just from having advised other clients that the way that you go about embracing Bagley-Keene and the requirements of the Voters First Act is all going to have a tremendous impact on how the public perceives your work. I wish you great success in your work, and I'm very excited about what you're about to embark on. Do you have other questions?
I do, Donna. On the access requirements, what officially are the avenues that we have to post when we're having meetings?
Oh, you, under Bagley-Keene, it's on the internet. You need to post the notice on the internet, and then you need to post the notice at the physical location where you're meeting, and if there are telephonic locations at each of those. It's different, that's an area that's different from the Brown Act, if that's what you're thinking of.
Yes, I was. Regarding the Brown Act, you mentioned earlier that there are minor differences between the two. Can you give me an example of the minor difference?
That's probably one. Another is the notice period prior to meetings, because under Bagley-Keene, it's 10 days, and under the Brown Act, it's just 72 hours, if I'm remembering that correctly. And then under the Brown Act, there's another limited exception that allows for temporary ad hoc committees to meet without complying with the Brown Act. That does not, that exception is not built into Bagley-Keene. There is no exception that allows ad hoc temporary committees to meet without compliance with Bagley-Keene. So.
I see. Thank you.
Quick question, Donna, while we have your expertise here, and I appreciate your very concise and thorough presentation here. I have a question. In the town that I reside, we're planning on having like a meet and greet session, meet the commissioner type thing. And it's very informal. That's on February the 10th. Does that have to be, do I have to go through the full notification? It's going to be at the library in Culver City.
It's just you. It's not a meeting. It's just you.
Okay.
And the issue that you would need to be more concerned about is not communicating about redistricting and what that means.
That's
so
going to be
you want to
the
have general,
question.
confine your comments to general things about the nature, things that are publicly known about the commission.
Okay, but we haven't actually begun any deliberations or discussions yet, so I should be fine. But if we did, or if we had discussed pertinent matters, then the pertinent matters would not be open for discussion, of course, but I can speak generally about redistricting, the importance of it to our community.
You can speak generally about what you're about to do. I mean, it's, yeah.
Yeah, involvement and participation. Okay, I'm okay with that then.
Yeah.
All right, thank you.
Well, thank you very much, and I wish you great success.